Hi, this is Blaine Cluten for Cluten Law. So the question today is, what's required in order to be able to change custody? There's two general situations that we're looking at, and that is where we're going either from shared joint custody to one party wanting sole custody, or from one party having sole custody and now the other party wants to change sole custody to themselves. If it's joint to sole and you're starting with joint and one of the parties now wants sole custody, the only uh, prerequisite or requirement is that there has to be a material unanticipated change. And one of the parties deciding that they don't want to follow the joint parenting time agreement generally is recognized by the court as being that change that's necessary in order to reach the threshold requirement for the court to make that determination about who should have sole custody. As far as sole custody changing from one party to the other, that requires a substantial change in circumstances. Now, what's a substantial change in circumstances? Um, Generally, the types of things that are substantial changes are things like drug abuse, relocation of one of the parents, abuse by the parent of the child. We're talking about substantial things, significant things. And assuming that you have one of those, and it has to be a change. It can't have been something that existed at the time that the judgment was entered. It has to be something new. And assuming you get to that threshold and the court does find that there is a substantial change in circumstances, now you're going to enter into the factors consideration about who should get custody. Now, those factors and considerations for custody are a topic for another video, but those two different scenarios are the most commonly seen for modifying and what the threshold requirement is before you can modify custody. This is Blaine Cluten for Cluten Law. If you have further questions about what change is required, please talk to an attorney. Thank you.